And then we are dismissing the burglary of a building with the plea.
Two cases are called, and 24 CR 844, which is burglary of a building. You're David Torres Jr.?
Yes, sir.
Okay, that one, it looks like is going to be dismissed by agreement of the parties. Then 24 CR 845, you were indicted for the third-degree felony of assault on a public servant. And you have earlier entered a plea of guilty. And this says it was enhanced because there, even though there's not a prior conviction in the indictment, the state in July filed a notice of intent to use prior convictions for enhancement at punishment. It states in paragraph number Roman numeral 3, number 1, under that particular paragraph in that motion, it is stated that you were convicted of the felony offense of burglary of a habitation in the 252nd District Court of Jefferson next door on August 12th, 2013, and were sentenced to 18 years in prison. And so that prior conviction is enhancing this third-degree felony to second-degree felony punishment. Thus, the agreement that was reached is whatever sentence shall not exceed a cap of 15 years in prison. So you would be looking at no less than 2, nor more than 15 years in prison. Plus, you could be placed on deferred or unadjudicated probation for up to 10 years. And there's an option there. I think you can be sentenced up to 10 from no less than 2, no more than 10 years confinement in prison. That could be suspended and you could be placed on probation for up to 10 years. I think those are the 3 options.
Yes,
everybody.
Sir.
Agree?
Agreed.
And you're gonna have to help me on this. I can't remember on the hearing that we held. Did we have a hearing on his plea already?
He pled guilty and then he pled true to the intent.
See, there's none of that's on the, none of that's, I got nothing on that file that's showing any of that.
And the indictment, the copies that we had did not have the enhancement, but as the court has correctly said, it was amended and he pled to that after the court went over it with him, enhancing it from a third
Yeah,
degree
well,
to second
okay, we got to pull him up, I guess, on whatever day that was that happened.
It was on July 22nd of 24.
No, I don't think so. We never know. Sometimes we forget to sign something.
Generally,
Yes, sir.
we,
Yeah, and I believe that it was all done orally and Mr. Torres was asked about it, but I don't for some.
what doesn't show in here, I don't have the transcript in front of me. What it doesn't show is how that prior conviction was supported in the record. I don't remember it. And I'm sure it was, we would have done it, but I don't know what we did. What did we do? Does anybody recall?
He pled true to it, to the court that.
Yeah, but there's,
One of the
how did
was
that,
318.
hold on. What generally is done is there is an enhancement provision in the indictment that's not done in this case, right?
Right, that's why we did the notice of state's intent to use.
Okay, and then I don't remember, there's nothing reflected in the file what happened. And I don't have a clear memory on what we exactly did, how that was all entered into. Does anybody recall? And what, there had to be some kind of a conviction put into the record, but I don't know how we did it. And did we do it? And did we do it, you know, effectively so that there's not a question later? That's all. There's nothing shows it. Well, generally we,
Yeah, and I believe that it was all done orally, and Mr. Torres was asked about it, but I don't precisely remember the court's.
all right.
You know,
Does the state have a, just to be on the safe side, does the state have a true and correct copy of that prior conviction?
We have a deferred adjudication order. I'm trying to make sure it has the revocation in it.
Was that out of Jefferson County?
It was out of the 252nd, Your Honor.
yes, sir.
Mhm. Well, it's something that can be acquired.
Page number? 13 dash 16367.
All right, back in this case, in Mr. Torres's case, what I have is a set of documents consisting of 16 true and correct copies of court papers in cause number 13-16367. And this is involving a burglary of a habitation indictment. And that cause number that was handed up on March 21st of 2013. It was a second-degree felony, and the defendant on May 8th of 2013 pleaded guilty to the court to that offense. The plea agreement was the defendant was going to be placed on deferred or unadjudicated probation up to 5 years in length, fined $500, and that sentence was to run concurrently with cause number 16368, which I don't know what that is. So it appears as though on May 8th of 2013, he was placed on deferred or unadjudicated probation for 5 years. And there's a deferred adjudication order signed by the judge of this court at that time, Judge Walker, placing him on deferred or unadjudicated probation. Then a motion to revoke probation was filed on June 13th of 2013, which was about 5 weeks later. And with that motion to revoke probation, within that motion, it is alleged, number one, that the defendant committed the offense of burglary of a habitation on or about May 21st of 2013 in Jefferson County, Texas. Which would have been a grand total of 13 days after he was placed on deferred or unadjudicated probation. So he pleaded true according to the motion to revoke probation document. As the court, I'm familiar with the way Judge Walker handled, and he either pleaded true or it was found true by preponderance of the evidence or greater. Along with these documents, there is an information cause number 298136 filed by the Criminal District Attorney's Office of Jefferson County, Texas, alleging that the defendant committed the Class A misdemeanor of burglary of a vehicle. That was filed on May 29th of 2013. 13. It was about 2 weeks before the hearing on the motion to revoke probation was held and the defendant's probation was revoked. There was a judgment adjudicating guilt that on August 12th of 2013, defendant's deferred or unadjudicated probation was revoked, and this judgment signed by Judge Walker in the 252nd District Court of Jefferson County, Texas. He was then found guilty beyond a reasonable doubt of the underlying burglary of a habitation for which he was placed on deferred or unadjudicated probation and sentenced to 18 years in prison. And then with that is an attachment A to the judgment order to withdraw funds. And then included in these documents that we're going to call Court's Exhibit 1 on this date, in this cause number, there was an appeal mandate that affirmed all of these proceedings for which the defendant was placed on deferred or unadjudicated probation for that burglary of a habitation, later revoked for the burglary of a vehicle, found guilty and sentenced to 18 years in prison. That is all called State's Exhibit 1 and consists of 16 pages. Any objection?
No objection, Your Honor.
No objection. Your
It's made a part of the record for all purposes. So, thus, here, how do I attach all this together? Court's Exhibit 1.
I have a clip here. Yeah.
Yeah, what's best for, because it's gonna it's gotta get scanned in and everything. Okay.
Well, that's why this.
So, Court's Exhibit 1, which shows the prior conviction for which the defendant pleaded true to. Okay, so now we have this before it's this 24 CR 845, which the defendant has earlier been indicted for assault on a public servant, a third-degree felony. He was indicted on April 17th, 2024. He entered plea guilty on, can't read that date. July 22nd, 2024, and he was facing second-degree felony punishment since this conviction was enhanced with the previous conviction of the burglary of a habitation in 13-16367, which is made a part of the record for Court's Exhibit as Court's Exhibit number 1 in this case. The court accepted this plea, ordered a pre-sentence report. Have the parties had an opportunity to review the report provided by the probation office? Any corrections or changes to its state and defense?
None from the state.
Judge, I reviewed this with Mr. Torres over the weekend at jail. He had a copy, I had a copy, and have some minor changes. In the first paragraph on page 1, Mr. Torres does not recall whether any of those things happened or not. He's not saying they didn't occur, but he doesn't remember anything that happened during that time. I think it's clear, though.
Why does he not remember?
He was under the influence of some type of drug, and basically there was a break-in at Beaumont Boat and Joint. When the police officers got there, they found him asleep inside the clinic, covered with a towel or a robe or something like that. And he doesn't recall what happened, after that. We're not disputing that it happened, Judge. He just doesn't remember it. What he remembers is in his version. Second issue, which I think
how did the
is,
drugs get in his system?
I,
You ate them.
yes, sir.
That's what the pre-sentence report reflects.
yes,
You ate the drugs. What drugs were they?
I don't know, this girl that I knew of from where I worked at had something that she said is gonna help keep me up, and I ate it, and it didn't keep me up. I kept falling asleep periodically. It was nothing I've ever experienced before. It's like I was in another world.
Do you find that a bad choice
Terrible.
to consume drugs that you apparently have no clue of what they are? Does that is that unsettling to you, or is that normal?
Wasn't a very wise choice.
You think? Yeah. Well, do you understand voluntary consumption of drugs is not a defense to any crime?
Yes, Your Honor.
It could also cause you to, jump off a cliff without a parachute, or go out and do worse things. If there's anything worse than ending your own life, but okay. So this is part of the defendant's version here in the pre-sentence report. By the way, that's been admitted into evidence without objection, correct, everybody?
yes, sir. Although I was in the process of making some
Go ahead.
changes, if
Keep going.
allow me. The second thing, under restitution issues, none were reported. When I got the report, I called Beaumont Bone and Joint and asked the office manager, who said that she was in charge of those things, what if there was any restitution. Told her who I represented. She said that the building is not owned by Beaumont Bone and Joint. It's owned by the hospital, by Christus St. Elizabeth. So I discussed with Mr. Bill Clement, and he provided me with this, Your Honor. I have it marked as Exhibit A.
No objection.
And I didn't get it till Friday, but I have provided a copy of it to Mr. Strong. But basically, $1,420. Some of it is glass, some of it is carpentry work to repair the entry that Mr. Torres did to the Beaumont Bone and Joint Clinic. And of course, they'd like to get their money back. But that basically are the only changes or additions that we feel would be necessary to the pre-sentence report.
Anything else from that? Anything else you want to bring up?
Well, yes, sir. I
Go ahead.
I would ask the court to continue to consider giving Mr. Torres either regular probation or deferred adjudication probation on this matter, so he could see that the restitution is paid, among other things. And we can get into to an argument. He basically went to TDC on an 18-year sentence, served 10 years, got out on parole, had been out on parole for over a year. I believe it was January 23 when he got out. Had been working in the food service industry at a number of places where he was steady employment. But he
The food service industry?
Yes, sir.
And he consumes things he doesn't even know what he's eating. What, people trust him fixing food for others? In a kind of confidential way back in the back? He's
Well,
fixing, I mean, he can't even feed himself proper food. He takes drugs and then breaks into buildings and then this is I was in another world. I kept waking up in a dream. The world was blowing up. I would pass out and then wake up again. I thought I died on my way to heaven. I tried to give some people a ladder to escape over a fence to get in a ship with me where I was getting my wing fixed and passed out in the bed. I wasn't aware of where I even was. I broke the glass. The lady was gone. I laid down on the bed. Someone covered me. I woke up. Someone said, "You're getting your wing fixed." I passed out and woke up talking to a police officer. So he's in charge of fixing people's food? This
well,
guy?
he was, I believe that he was more management type. The last place he
Management.
worked was
Okay.
the main event. He also worked at, where the other places you worked, other restaurants?
Olive Garden.
Oh, God. Olive Garden. And what else?
In addition to that, though, Judge, what he was in.
But you're not working there now for the safety of everybody. You're not working there now.
No, sir.
I mean, it's not funny.
No,
It's not funny. I
Yes,
mean, it's
sir.
not funny, sir. I mean, this is bizarre behavior and people rely on going to a restaurant and having a safe meal. I mean, eating a meal that's properly prepared and is safe. You you just consume drugs. You don't even know what they are, but you have no problem consuming them. And here you are again and looking at a lengthy prison sentence again. But there's a way to avoid all of this. You knew we were going to treat things seriously when you commit a crime, but you're breaking into buildings, causing harm to others because it costs everybody. I mean, can you imagine when people show up to work and there are people who need medical help over there and they got damage all over the place. They're having to clean up because you were getting your wing fixed on a ship in some bizarre tale of incoherence because you consume drugs that you don't even know what they are, but do it without apparently any second thought. I mean, it's just bad choice making. Again.
Further, Judge, he before he went to prison, he had a 7th grade education. He received his GED while he was inside, and also went to Business Computer Information Systems of the Gulf Coast and NCCER while he was incarcerated.
That sounds good, but what's the point you're making?
Well, the point I'm trying to make is he tried to better himself while he was in there, and I believe that he did that. He matured some.
But he got an
obviously-
education and went out and consumed drugs that he didn't know of, broke into a building and was getting his wing fixed in a plane. That doesn't sound like his education, his intelligence is any better from his education. He's making worse choices now with education. It seems like.
That's all.
I mean, is that about fair? Isn't that a fair analysis of what I'm making here? Yes?
Yes, Your Honor.
Okay, God bless you.
In addition to that, Judge, and I know that this steps into some of the court's arguments you've already made, he was employed almost the whole time he was on parole. until this event. And actually, he was working, the day before, had a job that was working at night, and it's just, I understand that the court will discount that, but I'll just point that out. I'd ask to give him one last chance.
It's a safety to others issue that bothers me. It's safety to others in the community, as well as himself. I mean, you don't know if what you're taking in a drug is going to kill you in the next 10 seconds. You don't know, but you didn't have a second consideration about it. You weren't hesitating. You were going to consume anything you can get. And then you caused a bunch of damage here to some people, a reputable business that takes care of people that some people had to be delayed in their assistance because at the bone and joint location, because they had to fix this big a mess that you had made. I don't know, it just seems like you're just making a mess and causing grief to everybody, including yourself. Oh, it's just, I want to hear something that's hopeful.
Well, Judge, the next thing in response to the court's last argument, this is one of those things where there was damage done. There's a victim. There's no doubt about that. But he didn't have a firearm. He didn't have any other weapon. He did not even have a motor vehicle when he committed this offense. I'm not saying that there is no public risk, but I'm saying that I think that this case, as opposed to some of the more violent cases that you see every day, does not measure up to some of those more violent cases that the court sees.
I would like to point out that he did bite the jailer when they were trying to take him into jail, so it's not without violence.
I don't dispute that, and he doesn't remember biting the jailer.
Keeping our eye on the ball, what we have here is he was indicted for assault on a public servant.
Yes, sir.
As well as this other burglary of a building.
And that's what the plea is too.
The assault on the public servant is the key thing, and that we're here about. The other is just how he got to jail, what caused him to get to jail, and he stated that he was not going to go to jail while at the jail, then fought back with the people who were trying to secure him. And then he bit a jailer on the left hand.
I also would point out that neither the jailer or the police officer involved in this were successfully contacted by the probation officer. And that's not to downplay any comments they would have, because I don't know what they would be. But the fact that they didn't contact, or when she tried to contact them, they didn't discuss the case, might indicate that this was not as bad as some other possible cases could be.
Okay. Well, the substance abuse history is about the most prolific this court has had to review. Marijuana daily at times. Synthetic marijuana, can't even recall when that started. Used a couple of times. Crack cocaine, can't recall when that started. A few times. Cocaine powder, codeine, LSD, one time. Ecstasy, crystal meth, Xanax, mushrooms. Let's see. It's daily marijuana since he was placed on probation. LSD numerous times, ecstasy numerous times. gas. Gas, is that? I see Freon numerous times. Gas, what kind of gas are we talking about?
Um, yeah, gasoline and
Gasoline, oh, you're just sniffing gasoline?
when I was younger, I did, yes, sir.
Oh, that'll cause you all kinds of problems. All right. See, he was treated back when he was 12 years old, for all of these problems, but it's like, it's not getting any better, you know? Okay,
I've heard the court many times talk about the best substance abuse treatment program that exists, being Safe P. And this may be the ideal person for that program. I mean, when he's 12 years old, it would have been great if it would have happened, but I think that's stretching it a little bit that he didn't learn his lesson back when he was 12. But he's here before the court.
it was 20 years ago, wasn't it?
You know.
Okay, what are you asking for? This is,
Well, as for deferred adjudication, and also for the court to consider substance abuse treatment.
okay. What do you say? Stank?
So he was asking for 15, given his criminal history, the fact that he committed these offenses while on parole, and that while he was also on parole in August, only 8 months after being let out, he committed a criminal trespass, and then after that, he burglarized a building and bit a jailer. He hasn't learned anything. He spent 10 years in prison already. State is asking for 15.
Okay, Mr. Torres, go ahead. Tell me what you would like me to hear.
Honestly, sir, Your Honor, my whole life I've not been dealt necessarily the fairest of hand, but I've worked with what I had and being around everything that I was growing up. I did have a problem with drugs. No, I didn't necessarily get the right treatment or the proper education or maybe watched right. So long story short, when I got in trouble when I was younger, I got out, got a girl pregnant, married her. When I was a kid trying to raise a kid, and when she left me, I spiraled down into addiction, what I knew to help me escape, I guess. And I went and did some stuff, didn't recall it, but know I was guilty of it. And when it's brought to my attention, I pled guilty, you know, because I own up to my mistakes, my wrongs, like I did now. No, I'm wrong. I'm not trying to say that it didn't happen. I just don't recall. I was under something that I've never been before, you know. That's, and I do need help. I do have a drug problem, and
Okay. Anything else by anybody?
There you go.
What do y'all think? What do y'all think is going to happen to Mr. Torres here if I sentence him to 15 years, which is fair? Which is fair. Under your circumstances and criminal history, which is fair. What's going to happen when he's released? Y'all think? Because it's not an aggravated offense.
Right.
So let's say it's 15 years and gets out 3 or 4 years. What do you think is going to happen?
He'll still be on parole for his other offense. He's on parole until 2031.
It didn't affect him last time. What do y'all think would happen?
I don't know, Judge. I think the only thing that
He does what he does. He gets high.
well, if he could get some help though, Judge, he may not do it again, but he hadn't had any help. And that's not the court's fault. I understand that. It's
Anything else?
No,
If
sir.
not, I'm going to find you pleaded guilty to the indictment and the enhancement, which makes this of the prior conviction, which makes this a second-degree felony. You have pleaded guilty voluntarily to the indictment, enhanced third-degree felony of assault of a public servant, enhanced to second degree felony punishment because of the prior burglary of a habitation conviction out of the 252nd in cause number District Court 13-16367. You have pleaded guilty and true to this second degree felony punishment voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here in this hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. I am following this agreement. There's a 15-year cap. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. Now, I'm going to suspend that. I'm going to place you on deferred regular probation, suspend that for 10 years. As a condition, you must complete substance abuse felony punishment facility. You must serve 180 days in the county jail as a condition of probation until you are released and sent substance abuse felony punishment. You are given a chance to help yourself. The problem is this: the next time you get a felony, it's 25 to life. I'm not doing you a favor. You got to do yourself a favor. But you have another conviction. That's 2 felony convictions now. You're one mistake away from 25 to life. And we've all had enough of your flagrant violations of and drug abuse for a long time. And your problems, your personal problems are not much different. Everybody's got problems. Everybody deals with them either responsibly or irresponsibly. You have been irresponsible. You've run out of next time. It's 25 to life, buddy. And you have lived your chances. You've had enough of them. You're not getting another one with me anyway. And depending upon the circumstances, but what we have before us, we've all had enough of it. You just make a mess. It's time to quit that. But you know better. You're able to make choices. You're just making the bad choices that you wish to make.
Judge, also, I'm sure the court is going to order him to pay the restitution to.
Yeah,
Christians.
restitution is going to be ordered in the amount, and that's to St. Elizabeth Hospital,
Right.
I believe, in the amount of,
$1,420.05.
and I want that paid as soon as you can. But we're going to review all of this. We're going to go from jail to safety, and then when you come back, make the most of this opportunity because you've run out of chances. I mean, you've been given more chances than others, and you can imagine next time we see you, shame on you, right?
Yes, sir.
Do it. Just everybody makes choices. It's not that hard to make the right choice. You have consistently, intentionally made the wrong choices. You run out of all of those. You can see what's going to happen. But the next felony is most serious. All right. Anything else?
Judge, just procedurally, I understand the court wants him to serve 180 days upfront time without credit for any time he served. And after his release there would be go to safety.
Yes.
Understand?
Yeah, I don't want his feet on the ground
No, yes, sir. Well, I think he has to be
until he's completed safe P. He goes from jail when that's fun to safe P. Then he's released and hopefully is in a position to make responsible decisions. Or else, you know what you're facing.
Yes, sir.
It's pretty simple. You're looking at up to 10 years with me and then whatever. But spitting on the sidewalk could get you illegally, could get you 10 years. Well, it's not funny. It's you put yourself into this position, but bad choices, but it's those bad choices must end. Because every bad choice from now on is toward terminal confinement. Okay, that's all.
Thank you, Your Honor.
I thought I.
You gave me one.
I didn't. Oh, I've got the other one. And is there a?